ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ ಕೆಎಸ್ಬಿಸಿ ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮಗೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ. ಇಂದಿನ ವಿಷಯ ತಮಗೆ ಈಗಾಗಲೇ ತಿಳಿದಿದೆ ಅಂತ ಭಾವಿಸ್ತೇನೆ. ಇಟ್ಸ್ ಅಬೌಟ್ ದಿ ನೋಟಿಫಿಕೇಶನ್ issued by the Bar Council of India framing the rules, that's the regulations, or the Bar Council of India rules for registration and regulation of foreign lawyers and foreign law firms in India 2022. Dear friends, the concept of LPG, that the liberalization, privatization and globalization, which ultimately resulted in the global village, has already entered the legal scenario and the law profession as such. The foreign law firms and foreign lawyers are finally allowed to establish their offices in India. But there's a big rumor that this will virtually percolate into the law profession and the foreign lawyers, arguing the matter before the courts and tribunals and all that. That is not the scenario as of now, because the area of practice is defined under the rules. Let me introduce the regulations, that's the rules framed by the Bar Council of India. As I said, these regulations are called Bar Council of India rules for registration and regulation of foreign lawyers and foreign law firms in India. Now there is a definition section which defines what is a foreign law firm, what is Indian law firm. It refers to several judgments of the courts, including the Madras High Court, Mumbai High Court, and ultimately the Supreme Court of India. Then the foreign lawyer is defined as a person including a law firm, limited liability partnership, company or a corporation by whatever name called or described, which is entitled to practice law in a foreign country. Now, foreign country means a country which is recognized as such by the government of India. It includes a constituent state thereof, in case such as a foreign country has a federal structure of the governance and such constituent state has its own justice delivery system and a separate class of persons entitled to practice law. Then foreign law, this is most important, means a law which is or was effective in the country of primary qualification. Now, international commercial arbitration is defined, international arbitration case is defined. Now, Rule 3 speaks about registration of foreign lawyers or foreign law firms and eligibility criteria therefore. A foreign lawyer or a foreign law firm shall not be entitled to practice in India unless it is registered with the Bar Council of India under these rules. Now, I'll straight away come to the area of practice because there are several factors which provide for registration of the law firms and the control over the law firms by the Bar Council of India, etc. Now, area of practice is defined under Rule 8. A foreign lawyer registered under rules shall be entitled to practice law in India in non-litigious matters only, subject to such exceptions, conditions and limitations as are laid down under these rules, and he shall be deemed to be an advocate within the meaning of sections 29, 30 and 33 of the Act. Please note, section 35 of the Advocates Act 1961 is not made applicable. Therefore, the Bar Council of India or the state bar councils do not have the disciplinary control over these lawyers. Of course, there is a subsequent rule which provides for cancellation of the registration instead of disciplinary proceedings, virtually repatriation of these lawyers back to the country from where they have come. A foreign lawyer or foreign law firm shall not be proceeded under section 5 of the Advocates Act. Rather, in case of any substantive misconduct, the Bar Council of India may cancel the registration of foreign advocate or foreign law firm as the case may be. Now, the area of practice, this is most important. Sub-rule 2 of Rule 8. The areas of practice of law by a foreign lawyer or a foreign law firm shall be laid down by the Bar Council of India, and if need be, the Bar Council of India may consult the Government of India, Ministry of Law and Justice in this regard. The foreign lawyers or foreign law firms shall not be permitted to appear before any courts, tribunals, or other statutory or regulatory authorities. Basically, they cannot file wakalat in any case before the court, a tribunal, or regulatory authorities where evidence is recorded. They shall be allowed to practice on transactional work, corporate work, such as joint ventures, mergers and acquisitions, intellectual property matters, drafting of contracts, and other related matters on reciprocal basis. Now, the area of practice, I am only reading out from the regulation, the rules. Mr. Nandakumar will define and elaborate rule, sub-rule 2 of Rule 8. They shall not be involved or permitted to any work pertaining to conveyancing of property, title investigation, or other similar works. The practice of law by a foreign lawyer and foreign law firm shall include the following areas: doing work, transacting business, giving advice and opinion concerning the laws of the country of the primary qualification. Now, the primary qualification is, as you must have read in the, of course, the definition clause I didn't find. Primary qualification is the one which they have obtained in their mother land. Providing legal expertise, advice, and appearing as a lawyer for a person, firm, company, corporation, trust, society who is having an address or principal office or head office in a foreign country, in any international arbitration case which is conducted in India, and in such arbitration case, foreign law may or may not be involved. Mr. Nandakumar will elaborate on this. I think this system is already in vogue. I'm given to understand. Providing legal expertise, advice, and appearing as a lawyer for person, firm, company, corporation, trust, society which is having an address or principal office or head office in a foreign country of primary qualification in proceedings before bodies other than courts, tribunals, boards, statutory authorities who are not legally entitled to take evidence on oath, in which knowledge of foreign law of the country of the primary qualification is essential. Now, providing legal expertise, advice concerning the laws of the country of the primary qualification and on diverse international legal issues, provided that such legal expertise, advice, unless otherwise provided for in these rules, shall not include representation or the preparation of documents regarding the procedure before the Indian Court of Law, tribunal, or any authority, other authority competent to record evidence on oath, or preparation of any documents, petitions, etc., to be submitted to any such forum regarding such procedures. Now, this is important. An advocate enrolled with any state bar council in India and is a partner or associate in any foreign law firm registered in India under these rules and regulations can take up only the non-litigious. Basically, he merges with the foreign lawyers, non-litigious matters, and can advise on issues relating to countries other than Indian laws only. Such lawyers shall have no advantage, right, of his being an advocate enrolled in India. Now, since I'm a bar council member, the last sentence means you are not entitled to the welfare fund. For example, under the Karnataka Advocates Welfare Fund Act 1986, you are not entitled to any of the benefits or the medical claim, which is medical facility or extending medical help amount for medical treatment, etc., from the Bar Council of India, or the amounts that may be given by the state government to the Bar Council of India to be distributed to the advocates in case of emergent medical needs and other things. Basically, you are not getting any assistance or rights from the Bar Council of India. Now, one more important aspect is the reciprocal arrangement is writ large in the rules that the practice of foreign lawyers and or foreign firms, a registration of foreign lawyers or foreign firms is only on the condition that their country allows Indian lawyers enrolled under the Advocates Act 1961 to practice in the area and to the extent in which they are allowed to practice in India. For example, today the Bar Council of India has provided the area of practice. This area of practice should be a mirror reflection in their country, provided in as much as the advocates enrolled under the Advocates Act 1961 should be able to practice in that area in the country from which these advocates come to India to establish law practice in the form of either individual or partnership concern or law firm authorities. Now, this is the just sum and substance of the rules. The Bar Council of India may expand the area of operation, area of practice. We do not know how it goes. So, Mr. Nandakumar, senior advocate from Bengaluru, Karnataka, who is practicing in Karnataka High Court and also before the Supreme Court of India, has agreed to elaborate the rules and the practice which is already there, which is in existence as of now, and the repercussions of the rules framed by the Bar Council of India. Welcome, Mr. Nandakumar. Kindly take over.
Thank you, Mr. Basura. Thank you. Thank you. Thank you for that introduction and the your introductory remarks. I think it really set the context quite well. It's also made my life easier in not having to go over a lot of the details of the regulations, though there are some aspects which I thought I would delve into. What I propose to do is to make my presentation into three parts. First is a sort of a quick brief history of what the story so far has been and what changes with these regulations. The second, which I think is important, is roughly some quick indication of what the nature of practice or legal practice outside of India is. We had some exposure in dealing with foreign firms and foreign lawyers. So that is the second leg of what I propose to present. The first is a brief history. The second is the nature of practice abroad, and the third is some issues or some points which I see with these regulations, which I thought I can highlight to you for your consideration. Now, taking up the point on the brief history, if you notice, Mr. Basavaraj straight away went into the rules themselves, but there's a fairly long narration of the objects and reasons. And the one thing that really I found quite impressive was that the Bar Council has categorically stated how it was originally opposed to the idea of foreign firms and foreign lawyers coming in, but has thereafter changed its mind after due deliberations and so on and so forth. And I think that's a very welcome sign to see in any regulator. You want a regulator to be progressive. You want a regulator of any form, and it could be a regulator of a profession, it could be of an industry. You want the regulator to be progressive and to be slightly far-sighted and to be willing to change its opinion. So that's a very welcome note. It starts with the premise that the law is a noble profession and it's not really a business and so on and so forth. The one thing I wanted to just comment on is that if you look at the way law, I don't want to make this crude, but if you look at how law is practiced abroad and how when you look at a lot of the law firms abroad, just to give you in an order of magnitude, the largest firm in the world by revenue, and I just looked at some statistics from 2021, is a US firm which had a turnover of, subject to being corrected, $6 billion US. Now, that is the turnover of arguably some of the larger Indian companies. So it's a pretty large setup that they have. Some firms tend to be more profitable, some firms tend to be less profitable, and so on and so forth. So this sense of the nobility of the profession, that's again partly from our Indian tradition and partly from the British legacy that we have, is not entirely something that the entire world agrees with. There are different parts of the world which don't necessarily share the same view, and going forward, that part of evolution is something that the Bar Council may have to keep in mind. I'm not saying that we should disregard the nobility of our profession, but I'm only saying that you must be conscious that many other lawyers around the world don't necessarily see it in the same light. That's one point I wanted to make. The second was that if you look at the whole principle, it is that there is a lot of international trade and therefore migration. There's migration of services, of products. You have software engineers trained in India who can go abroad and work. Why can't lawyers trained in India go abroad and work? Or similarly, you have professionals who are, say, for example, construction experts who are trained in Australia, who can come and execute, say, for example, the construction of an airport in India. Why can't an Australian lawyer come along who's an expert in construction disputes and work in India on a project like this? Now, again, just to emphasize this point a little more, if you look at a construction dispute, now there are very many different nuances to that dispute resolution that occurs in an international dispute, in an international construction dispute. You will have something called a dispute resolution board, which often looks into these matters. You will also have arbitration. You will have something called a de minimis clause, which means that issues which are below a certain threshold, you can't even raise in arbitration. You will also have issues where you have experts who come into the picture, who give expert evidence, delay analysis, damages, costs experts, loss adjusters if there's been an accident, all sorts of very, very nuanced specializations which are weaved into a part of what practice goes on. A lot of that is now beginning to be seen in Indian disputes as well. So that is another aspect that's just to be borne in mind in terms of the migration of services and specializations that we are seeing with international trade. And like I said, the Bar Council appears to have had a lot of consultations with the bar authorities in the UK and the government authorities both in India and the UK, and then some of these regulations have come about. Now, just by way of a quick history, one of the first cases was the Lawyers Collective case in Bombay, which was decided in 2009, subject to being corrected, which basically the question there was, could a liaison office of a foreign law firm be set up in India? I don't want to get into the names, that's not important. And the Bombay High Court took the view that it couldn't, and also seemed to remark that even non-litigious work falls within the fold of the Advocates Act, and therefore they couldn't perform such work. Then you had the case of A.K. Balaji from the Madras High Court, which basically said no practice by foreign lawyers in India. But then it said that, look, if there is fly-in, fly-out basis. Now, this is fly-in, fly-out basis is something that's been noticed in the objects and reasons, as well as in the rules that you will see if you take a careful look at it. And therefore, if it's advised on foreign law, now, for example, if you have a contract that is substantially being executed in India, but it has UK law as its substantive law, or say, for example, German law as its substantive law. Now, you are going to struggle to find enough Indian lawyers who are experts in UK law and are qualified to advise on UK law or German law. And therefore, you might need some of them to be able to help you with the dispute. And it's always not practical to have to send everybody away from India, make a trip to Berlin, and then come back. Sometimes it's just easier to get 2 German lawyers on a flight to Bangalore or Madras or Calcutta or wherever it was. So that's part of the fly-in and fly-out concept that was introduced. The other thing that I think the Madras High Court, and I think a very far-sighted view, was that when it comes to international commercial arbitration, obviously given the nature of international commercial arbitration, it's very difficult to have such a restriction. So obviously given that nature, they said that there could be some relaxation. Now, all of this went to the Supreme Court. And the Supreme Court in 2018, and interestingly, all this is recorded in summary in the objects and reasons. So it's useful to take a look at the objects and reasons in some detail. They basically said no to practice in all forms. But again, they said that fly-in and fly-out is fine. They picked that up from the A.K. Balaji's judgment of the Madras High Court. But they said you can't make it a regular feature. So you can't say I'm flying in, flying out, but do this, 5 times a month, every month. That's a lot of trips, and that they're not okay with. But if it is really a fly-in and fly-out thing, if it's one matter, one transaction, that sort of thing, that's okay. Even with international, of course, the other thing they said was that they did indicate that the Bar Council could make rules. I think that's also referred to in the objects and reasons, and therefore it's pursuant to that, as well as the powers under the Advocates Act, that these rules are made. And then with international arbitration, again in the Supreme Court judgment in 2018, they said it's not a blanket yes, but they sort of left that open, and to some extent they lean towards the Bar Council to make the rules. Now, coming to some specifics of the rules, before I go into the nature of practice outside of, actually, I might just do the nature of practice outside of India first. There are a few things that, if you look at how law practice is structured abroad, obviously with different countries, it's different. Now, there are 2 large broad streams, the common law countries on the one hand and the civil law countries on the other hand. On a lighter note, there are those who think that there is a third category, which is that there's no law at all, but I don't want to get into that. The civil law, the common law countries are those which at some point or the other have had some British influence, and therefore, India, Canada, Jamaica, Fiji, all of these, Singapore, Hong Kong, all of these countries, to a large extent, the nature of the setup of the courts, the manner in which the civil procedures are conducted, the codes that you have, the civil procedure code, the penal codes, your statutes, a lot of them are very, very similar. For example, you will find that if you take the Indian Penal Code, there are very, very similar penal codes in Malaysia, in Nigeria, in different countries. So also with various other statutes. So you will find that there is some degree of commonality in practice in these places. But let me just be a little more specific here. When it comes to the UK, for example, there are, roughly speaking, two broad categories of practice. One is where there are law firms, and then there are these chambers of barristers. Now, much like the system in, say, for example, Bombay or in Delhi, where you have the AORs and then the arguing council. Now, the law firms do a lot of corporate and transactional work, and they also do litigation. Many of them offer what is called a full service, which means that they'll do your advisory work, they'll do transactional work. What do I mean by transactional work? Some of you may not be familiar. That means that if there is, say, a proposal for an Indian company to take over a British company, for example, the Tata's takeover of Land Rover and Jaguar, the firms will advise on it, on a lot of the regulatory aspects around it, how the transaction can be structured, and then they'll go about doing the documentation that's relevant to ensure that the transaction is fructified. That is typically transactional work. Then advisory work as to, can I do this business? Is this contract all right? And so on and so forth. That's advisory work. And then you also have, you will have their disputes team, which will have their local litigation as well as international arbitration. Now, a lot of law firms also have these investment arbitration teams. Now, those are where there is a company that is suing another country pursuant to a bilateral investment treaty arbitration. Other than this, if you just out of curiosity, what I think is useful is for some of you who are not familiar to actually go to some of these websites of these firms to just take a look at how they're structured. You'll find it quite fascinating. The areas of practice that they offer are actually mind-boggling. Some of them are experts in shipping, some of them are experts in insurance, some of them are the world leaders in banking and finance, for example. I've worked very closely with a firm in the UK which does a lot of aviation work, for example. They are so specialized that there is a team which handles only aviation lease financing. There is another team which handles only aviation insurance claims that arise out of accidents. I remember there was one dispute that started in the year 2007 relating to an accident of the year 2004. The partner that I met who wanted, the case had to be filed in Bangalore, so that's how I was involved in it. It was extremely enlightening and enriching for me because the partner who I met from the UK firm had, at that point, I'm talking about 2007, had aviation claims disputes experience in 66 different jurisdictions. That's, mind-boggling experience and perspective that he can bring to the table. So there is a lot of specialization that occurs in these law firms. Then comes the chamber of barristers that you typically see, which are like an association of persons. What they do is that they each are sort of offered a tenancy depending on their qualification. There's a committee that screens them. And then they are often briefed by these law firms to appear in court or in arbitration matters. To that extent, it's not very dissimilar from the way we practice. But having said that, Bangalore is not necessarily a great example of representative sample, because in Bangalore, what happens is that because you don't have a strict distinction between solicitors and counsel, a lot of people end up doing both, or most people end up doing both. And very typically, it's only after designation that you just get briefed by others and so on and so forth. But in many cases, there are lawyers who just appear on the instructions of others. Now, this is one part of the story. Then when it comes to, say, for example, the US, the more popular model is that they have law firms. The number of individual lawyers are, there are, especially in the smaller towns or in smaller practices, you will have individual lawyers or teams of lawyers getting together and practicing. But typically this concept of chamber of barristers is a little lesser, or it's not prevalent as much. And you'll have, to some extent, specialization. Obviously, the big difference is in the US, they're allowed to advertise. So therefore, like I said, that's the point I made at the beginning about the nobility of the profession. It's a very different perspective in different jurisdictions, and that's something that we need to be conscious about. So the key points to me from an international practice perspective are: one, specialization; two, professionalism; transaction and disputes work, and then under the dispute international commercial arbitration piece. Now, coming to I'll definitely not repeat that, but I'd like to point out a few things which I thought need a little more attention, a little more detail. The first point, which I don't know if this has been done or not. I tried to find out on the internet and I couldn't find any information, and perhaps Mr. Basavaraj can throw some light on it. I don't know if there was a public consultation before this was done. Now, obviously, when the whole process of the A.K. Balaji judgment and the proceedings were going on, and even before that, I remember when the lawyers collective matter was going on in the Bombay High Court, there was a lot of furor in the bar. The bar was very resistant to it. There was a lot of sense that, oh my God, these foreign lawyers will come and take away our daily bread and that sort of a thing. Now, the present rules, I haven't seen that furor yet. I mean, obviously, it's still very early days. It literally came out yesterday, day before, so it's still very early. But I haven't seen that furor. I haven't seen that reaction yet. I haven't heard too many people in the bar losing sleep that, oh my God, there are these foreign lawyers that are coming. Having said that, one, obviously, because they aren't allowed to practice directly in Indian courts, your typical motor vehicles case, your land dispute is not going to go away. So those of us who are engaged in the bread and butter of the city civil court practice are not likely to, nothing is likely to change.
Basically, they cannot touch Indian laws.
But yes, that is so. But there are a couple of caveats which I wanted to come to a little later when we look at the detail. If you look at the definition of what a foreign lawyer is, it's very interesting because it says that a foreign lawyer is a person, including a law firm, limited liability partnership, or a corporation, which is entitled to practice law in a foreign country. Indian lawyers means an advocate enrolled on the roll of a state bar council in India in accordance with the provisions of the Advocates Act. Fair enough. Now, what I think it does not provide for is lawyers who are dual qualified. And this is a very, very important piece. What do I mean by this? A very, very large number of people I know, a lot of my classmates, seniors, juniors from different colleges, including my own, have obviously graduated from an Indian university, are typically Indian citizens, have enrolled with a state bar council, Bangalore, Bombay, Delhi, Madras, doesn't matter, and have also proceeded to go abroad, have often done their masters there. Some haven't, but some without that masters have also got the professional qualification of, say, UK, Canada, US, whatever else. I think in the case of the US, you do need a further study stint there, but that's a matter of detail. In Singapore, in different countries. And well, today they are actually entitled to practice law in India. They're entitled to practice law in, say, for example, Singapore. They're entitled to practice law in the UK. Where would you fit them under these regulations? Because if you go by the strict letter of the definition of a foreign lawyer, they are a foreign lawyer. If you go by the definition of an Indian lawyer, they are an Indian lawyer. But the rules don't really talk about what happens to a person who's dual qualified. My sense is that it should not apply to them. Because as long as you're an Indian citizen with the ability to practice in India because you're qualified in India and you haven't surrendered the rights to practice or the license to practice, I don't see why you should go through another additional requirement when you otherwise did not have to. Suppose these regulations weren't there, were they allowed to practice? The answer is yes. On a lighter note, the Chief Justice of our country has more than one degree from Harvard, and subject to being corrected, even practiced in the US before he came down. I just see a message from somebody saying that triple qualified. I know some others who are as well. So we don't want them to drop off onto the Indian Ocean. That's not the idea, and that shouldn't be the idea. So it's useful if at some point the Bar Council clarifies this just to put this to rest. But my sense is that the regulations don't address it. And my further sense is that the regulations are not meant for them. But there is a small catch here, which is when you think about it, if you see, and I'll come to that when I mention my comments on Rule 3 as well as Rule 8, they typically are also a foreign lawyer, and they can advise on foreign law, whether they're in India or in the UK or in Singapore or wherever else they are. So what do you do in a situation like this is a question that can come up, and I suspect may come up. And that so therefore, the sooner that this gets sorted out, the better. But my reaction to reading of these rules is that it should not apply to people like this who are otherwise entitled to practice in India without any restriction whatsoever. For example, I might be, and I know that, for example, there are some senior advocates in the Supreme Court who are called to the bar in the UK, they're called to the bar in Singapore, they're called to the bar in India. They are entitled to appear in all of these countries. I mean, it's a right that they have given to them under law. Why should that be taken away now because there is a new regulation? I don't see the sense of that. So my sense is that it should not apply, but it behoves some clarification. The next question, which just to react to what Mr. Basavaraj pointed out, the country of primary qualification is defined in 2 small Roman 5 as the country in which the foreign lawyer is entitled to practice law as per the law of that country. This again doesn't address dual or triple qualification as Purvi quickly pointed out. So that's something that again is something that needs sorting out. But having said that, if you read that with foreign law, I suspect it means that it shouldn't apply, but nonetheless, that's something that you need to think a little about. Then coming to the definitions of international commercial arbitration and international arbitration case, I found this a bit interesting. Part of the reason why it's interesting is that the Supreme Court has made a distinction between arbitration proceedings and arbitration cases, which are cases in court relating to arbitration. For example, your Section 9 petitions, your Section 34s, and so on and so forth. Now you have a situation where an international arbitration, which was seated in India, can obviously be challenged in India. You can move the court for interim measures in India and so on and so forth, as long as India is seated. If you look at it a bit carefully, international commercial arbitration is obviously fine, but international arbitration case means an arbitration case concerning a commercial or monetary matter which is conducted in India, in which all or any of the parties who have an address or principal office are in a foreign country. Now, why would you make a distinction between an arbitration case and an arbitration in and of itself? The only reason I can think of is drawing a distinction between an arbitration and proceedings in court relatable to arbitration. Now, if it is the latter, then this is essentially a foothold into court, which I don't think is the intention. So this is again something that needs some clarity in my view. Then the next comment which I wanted to make was on Rule 3, which is about a foreign lawyer shall not be entitled to practice law in India unless he's registered at the Bar Council under these rules. That we'll look at in a little more detail in Rule 8. I am not really going to go into the details of the process of application and what all they'll scrutinize and when they'll say yes, when they'll say no, because that's a matter of detail. But the proviso to Rule 3.1 is very interesting, and I find it interesting because provided that this prohibition will not apply to law practice by a foreign lawyer or foreign firm, in case practice is done on a fly-in, fly-out basis for the purpose of giving legal advice to the client in India regarding foreign law or on diverse international issues, provided further that such expertise or advice of a foreign lawyer has been procured by the client in a foreign country and foreign lawyer or foreign law firm does not maintain an office in India for the purpose. And lastly, the practice does not exceed more than 60 days in the last 12 months. Now, this is precisely what I was saying. This proviso is essentially what is already happening. If you look at your live law or bar and bench for the reports, not so much on what happens in court, but on the transaction reporting.
Daksha Legal.
Sorry?
Daksha Legal.
Daksha Legal, thank you. Yes, Mr. Basavaraj, how can I forget? Though I think you need to do a little more on the transaction reporting on the larger transactions, but nonetheless, if you look at those, what you will find is that in most transactions which involve mergers and acquisitions, or even say, for example, a very large rights issue, you take one of the more prominent ones, the Paytm IPO, you will find that if you look at the report on one of these websites, it will tell you how such and such law firm in India advised the book running manager, and such law firm in the US or the UK advised the book running manager. Then such and such a company or law firm advised the main company and in India, and this was a correspondent law firm sitting out of Singapore which advised the company. So that is essentially what is already happening, because they are advising on the foreign law aspects. They are still sitting in Singapore or in the UK or in US or wherever else they are, advising on those aspects. They're also possibly advising on, say, for example, if you take a company to, through the IPO process and they are now listed on the stock exchange in India, what happens then? Because then there can be the next trigger in many of these documents or these agreements. The next trigger is that they will, if they reach a certain turnover threshold, there may be a requirement that they also have SEC filings and reporting requirements there. And so obviously you need a US firm which can advise on that. So this is essentially something that's already happening. So the proviso to some extent really dilutes the need for practice or need for a foreign firm or a foreign lawyer to come into India, except that it is clear in saying that they shouldn't have an established office here. Now, I do hope and trust that this will not be circumvented by them using the sort of common shared workspaces and trying to say that they don't have an office. I don't think that's the intention either. The question typically will be of, do they have a presence in India or do they not? And I suspect that's something that they'll have to look at and answer. To what extent there's going to be regulatory scrutiny over this, I really don't know. It's an interesting question and it's something that we need to look at. The one comment I wanted to make on the application for registration, it's a point that Mr. Basavaraj made. If you look at Rule 4.1 and that small Roman 3, it requires a certificate from the government of a foreign country of primary qualification that advocates enrolled under the Advocates Act 1961 are permitted to practice law in that country. So it could be UK, Singapore, wherever else, in the manner and to the extent that is comparable to the law practice permitted under these rules along with copies. So that's exactly the point that Mr. Basavaraj was making, that if I am entitled to practice in the UK basis, not just the Indian qualification from an Indian university, but also the license that I have from the Bar Council, with that, I should be able to practice in the UK subject to them, obviously, whatever regulations they have, but them recognizing such qualification. I think the focus here would be on the recognition of the qualification and not anything else. Because I don't think it's fair or right to say that I should just be allowed to walk into a court in London or in Singapore and then start arguing there. I don't think that's the intention either. And well, the fact is that I won't be allowed. But if I do apply through the right process and the equivalent rules in the UK or in Singapore or in Hong Kong or wherever else, would I be allowed to practice there basis the qualification that I have here in India without having to undergo the whole process of qualifying and recognition all over again? If the answer to that question is yes, to my mind, it's a reciprocal arrangement. And that's, I think, typically how it would work. That's typically how it does work in any case before these rules came into force. Now, I'm going to skip the rest of the process of the application, and I'll straight away come to Rule 8, which is actually quite interesting. The thrust of the focus is on foreign lawyer being able to practice in non-litigious matters. But there are some exceptions, and I'll come to that. Devil is in the detail, as they say. But having said that, this is actually a question that you might ask yourself: if there is only this to be done, would the foreign firms come into India or not come into India? A friend of mine had put some statistics together on a note that he put out earlier today or yesterday. I'm not too sure. Apparently, the annual revenues from the British Magic Circle firms, those are the top 5 firms in the UK, on worldwide offices is about anywhere between 1.5 billion to 1.8 billion British pounds. So his estimate is that the entire international legal services market in India is about US dollars 1.65 billion. And his sense is that there is a greater outflow of Indian services to foreign clients than vice versa, which obviously means that for foreign companies investing in India, which need Indian law advice, Indian law firms and Indian lawyers are able to sort of bill more than Indian companies on outbound transactions. If that is so, it's typically a happy thing for Indian lawyers, but somewhere I think the overall purpose of these rules is to also try and bring some better equilibrium. I'm not too sure it will be achieved immediately, but that's something to be seen. The other thing that's important, and two important points from the rules are, part of the application requires them to indicate what their fee structure is going to be. And I think that's a bit, I don't know. I mean, I'm not too sure they'll want to put that out so easily. So that's something to be grappled with. The second thing is that it doesn't also restrict a foreign firm or a foreign lawyer from advising an Indian entity or an Indian client on any foreign law issue in that overseas territory. So to my mind, it's a bit of a, it's a bit of a narrow area that there's actually a focus on under these rules. Now coming to Rule 8.2. There is the area of practice that will be laid down by the Bar Council along with the Union of the Ministry of Law and Justice, which is fine. The foreign lawyers or firms would not be allowed to appear before Indian courts, tribunals, or regulatory authorities, which is also expected. They shall be allowed to practice on transactional work, corporate work, joint ventures, mergers, acquisitions, intellectual property, drafting of contracts, and other matters on reciprocal basis. Well, the fact is, for example, if they draft it in London and send it to you by email, they're still actually doing the work already. But I think the principle is that if you are setting up office in India, then on reciprocal basis, as long as you allow Indian law firms to go abroad and set up an office in London, you're free to. Now, has that happened yet? Have enough Indian law firms set up offices abroad? Well, it's beginning to happen. I know some which have set up offices in Singapore and in New York and so on and so forth. It's not happened enough yet. I know of instances where there are very large Chinese law firms which have, I think, taken over effectively an Australian firm, subject to being corrected by somebody in the audience. So you should probably see some more of these, and I do wish that Indian firms, and some of them are they're amongst the best lawyers in the world when it comes to these transactional matters, put themselves out a little more in the international space, because I think their time has come. That's something that I'd like to see a little more of. But the foreign firms should not be involved in conveyancing and title investigation and so on and so forth. The chances of them doing that are actually quite low. But having said that, this again is possibly a sort of a bread and butter for the local Indian lawyers, and that's one reason why it's kept insulated. The other reason could be that the port of reference and the point of reference for these regulations are also the UK system, where again there is a restriction on, say for example, a foreign lawyer trying to practice in conveyancing or in probate matters and things like that, which is actually captured in the statement of objects and reasons. So that could be the reason why this is sort of this reciprocity, and to that extent, to me, it's understandable. The details are under this, which says practice of law by a foreign lawyer or foreign law firm shall include the following areas: small Roman 1, doing work, transacting business, giving advice and opinion concerning laws of the country of primary qualification. Obviously, they can do that. But what are the chances that, let's say, a French law firm or a US law firm sets up an office in Bangalore or in Bombay, and somebody comes to them for advice on French law or US law? What are the chances that that will happen? So to me, it's a bit too narrow. The second one is interesting: providing legal expertise and appearing as a lawyer for a person, firm, company, trust, society, which has address in the principal office in the foreign country, in any international arbitration case which is conducted in India, not international commercial arbitration, international arbitration case which is conducted in India, and in such arbitration case, foreign law may or may not be involved. So this is the point I was making. If you look at the definition, the distinction between international commercial arbitration and international arbitration case, they make a distinction between the two in the definition. And in, this is 8.2 sub small Roman 2, they talk about representation in and appearing as a lawyer in an international arbitration case. But given that they've taken away the right to appear in a court, I am not too sure what this is meant to serve, because if you are either in an international arbitration or you're in court, I don't know what space there is between the two. If it is advice around that arbitration, advice around that case, obviously they can do it in any case, they can do it today. There is no bar. So I don't know what this is intended to address. So to me, this is a bit lacking in clarity, and maybe something that they need to sort out a little more as time goes by. Small Roman 3 is again a bit interesting. Providing legal expertise, advice, and appearing as a lawyer for firm, company, trust, etc. Before bodies other than courts, tribunals, statutory bodies who are not legally entitled to take evidence or not. So I don't know what other bodies there can be, but nonetheless, it could be being able to say correspond, for example. It could be, for example, the ability to issue a legal notice. That's something that they could potentially do using this. Again, 4 talks about diverse international legal issues, but shall not include representation or the preparation of documents, including procedures and so on and so forth. And then 5, provided that an advocate enrolled with the State Bar Council is a partner or associate in a foreign law firm registered in India under these rules and regulations, can only take up non-litigious matters and advise on issues relating to countries other than Indian law only. Such lawyer will have no advantage. Now, Mr. Basavaraj clarified on the advantage. Now, let's assume that that is acceptable and people have said that's fine and moved on. But I am actually unable to understand this restriction in full. And I'll explain what I see as the pros and the cons of it and why this is probably intended. What happens is that when a foreign firm sets up, now I'll give you the example of Singapore, which and foreign firms working in Singapore, I'm a bit familiar with it. In Singapore, there are international firms which have local presence. Again, there is a similar qualification requirement. You need to apply to the Singapore bar, obtain a license, and only then set up as an international firm. Or you can tie up with a local Singapore firm. Both are fine. But if you do the international firm, unless you also have local practice entitlement, for which you need an Indian lawyer, a local Singaporean lawyer, you can't go to court. That's the typical rule. I mean, I'm saying this in a very brief and succinct manner, but there is a lot more detail behind this. But if you look at the normal practice, you will obviously, if it's a UK firm, you will obviously have a few British lawyers who are, quite happy to escape the London weather and sit in sunny Singapore and enjoy the climates there. But you will also have a large number of Singaporean lawyers, locally qualified Singaporean lawyers who are working with those firms. But if you now say that such lawyers can't appear in court, then the ability of these foreign firms to actually attract local talent is going to be quite restricted, because a lot of people may not be willing to give up their right to practice in India. Is something that might need revisiting at a later point in time. So to me, this is but of course, I can see the reason why it is done, which is possibly that you don't want, under the guise of setting up an international law firm in India or a foreign firm in India, the foreign firm being able to employ, say, for example, 100 lawyers and start practicing in India or in Indian courts. Maybe that's what the intention is to avoid. But to me, this might create a bit of an impediment in them getting good people. And if the intention is really to encourage cross-border...
I'm sorry, the Bar Council of India has taken care of the local advocates. If you go to further, after Roman 4, if you come to Roman 2, to engage and procure legal expertise advice of one or more Indian advocates registered in as foreign lawyers.
No, that's right. But the point is that
Roman 3,
look at
local lawyers.
Yes. But these are Indian advocates registered as foreign lawyers.
Yes.
It is not Indian advocates who can otherwise practice in Indian courts. But if you now read 8 to small Roman 5, they will essentially be disabled from practicing in Indian court, though they are otherwise Indian qualified. Now, for example, if I am only India qualified and I'm not UK or US qualified, and a UK firm sets up an office in India and I join them, I can't then practice in an Indian court if you look at small Roman 5 of 8.2. And 9.1.2 does not take away that. That is the point I was trying to make. So that was another thing. To me, a large part of this these rules are intended to ensure that India as an international arbitration hub is promoted. As of now, that's still a work in progress, and one hopes that if more firms come in, the ability of India's churning out of international disputes, not just of local Indian disputes or involving one Indian company, but also two unconnected entities. Say, for example, a Bangladeshi company fighting a Mauritian company might want to arbitrate in India. Those cases are more likely to come up, and one hopes they come up, and one hopes India also is able to build better arbitral institutions. We all have already seen some coming up. So to a large extent, these rules are, I think, intended in that direction. The other point I wanted to make was that if you, like I said, go to the website of any one of these large international firms, be it UK, US, doesn't matter, you will find that they'll typically have offices in 50 places in the world, 80 places in the world. I mean, there'll be some 20 cities in the US, 3 in the EU, I mean, maybe about another 20 in Europe. And then they'll have offices in Singapore, Hong Kong, Bangkok, Jakarta, everywhere, but none in India. I think to some extent that will change with this. But are you likely to see, flight after flight of foreign lawyers coming in, and your civil courts and the high courts being packed with Singaporean lawyers and the UK lawyers? That's not likely to happen. Is there going to be some change in the transactional space? I think there will be. What are the advantages of foreign firms coming in? And this is a very important point, I think, that we must accept. Certainly, they have excellent processes and systems. Their record-keeping ability is phenomenal. It's really something that a lot of us need to see and learn. The exposure that they bring, the example that I offered of the experience that they bring in specialized areas is truly phenomenal. And there's a lot to be learned. I mean, one can't emphasize enough to what extent they get specialized, but sometimes that specialization is our undoing. In India, the average lawyer does everything: employment law, matrimonial law, commercial law, tax law. I mean, and will typically say, okay, I won't do a murder trial. Or a criminal lawyer will say, look, I don't mind doing everything else as well, or whatever, right? But that simply doesn't happen in many places overseas. So therefore, that is something that might again start some change and some greater degree of specialization. We've already seen some trend in India with that, but maybe this will be a much more pronounced trend. But it's a very, very interesting and welcome development in my view, and one that we need to wait and see how it shapes up. Thank you.
Thank you, Mr. Nandakumar. I just wanted to read Roman 8:5.
Yes. Yeah.
Provided that an advocate enrolled with any state bar council in India and is a partner or associate in any foreign law firm registered in India, under these rules and regulations can take up only non-litigious matters and can advise on issues relating to countries other than the Indian laws only.
Right.
So if you're a part of the international law firm, basically you cannot deal with the Indian laws if you're an in-house lawyer.
Right.
Now, if you see 9:3, the registered foreign lawyer firm shall be entitled to the following things in connection with the practice of law in India: to procure a legal expertise / advice of any advocate enrolled with any state bar council in India on any subject relating to Indian laws. Therefore, as an outside advocate, I can, they can engage me for the purpose of giving the legal advice and opinion about the Indian laws.
Right.
But I didn't understand. This is okay. In-house lawyer is completely, he cannot deal with the Indian laws at all.
I'll just make the point a little more elaborately. You're absolutely right in saying 9:13 allows them to engage an Indian lawyer. For example, much like, say a client today can ask you for an opinion or ask you to advise on an Indian law issue, a foreign firm which is registered in India or a foreign lawyer registered in India can come to you for that advice and you can offer that advice. There is no difficulty there. The difficulty is that if I am typically the model that a law firm follows in India or in the US or in the UK or anywhere in the world is that they will often have you on a retainer, which means you are expected to do work only for them and not for anyone else. In India, it's a retainer. In many countries abroad, it's a salary because there is no restriction like there is in India on not being able to take a salary. Now, if that is so, and I am a retainer and on the rolls essentially, though not as an employee of a foreign firm, then I'm precluded from practicing Indian law is what 8 to 5 seems to suggest. And that is where I'm saying that there may be a bit of a catch. Now, that means that a foreign firm which wants to set up an operation in, say, Bangalore and wants to have 60 lawyers will be restricted in as much as it can't have the ability of saying, okay, I have 8 people who can advise on French law, 7 people who can advise on US law, but I cannot have anybody, I cannot do anything about Indian law. Having said that, we have somebody outside like Mr. Basavaraj. He's an expert in, say, for example, this aspect of law in Indian law. We can consult him and he can advise us. But Mr. Basavaraj is an independent practitioner and he's not a part of the firm. And they can't hold themselves out at all as being able to offer any help with Indian firms, I mean, with Indian law. To me, that is a bit counterintuitive, because then what is the purpose of them setting up at all in India? They might just as well as set up in wherever they already are. So this is a bit of an unwelcome step for a foreign firm is the point that I was trying to make.
The one of the reason appears to be that the apprehension, about the Indian advocates being sidelined and all. Therefore, this is a perfect balance according to me. Indian lawyers are protected. At the same time, the foreign law firms are also permitted to engage the services of any. No, I did not understand 9(2) to engage and procure a legal expertise advice of one or more Indian advocates registered as foreign lawyers. Now, foreign lawyers, the word is defined.
Yeah, as somebody who's, yeah, you're right. So that is the other point I wanted to make, because
And for example, if they have a litigation before the court of law,
then they'll engage an Indian lawyer, because a foreign lawyer anyway can't appear in the Indian court.
No, before I throw open the question and answer session. Now, today, suppose if there is an international arbitration in India between for example, Mercedes-Benz and a local distributor, and the matter is referred to arbitration, and the law is maybe a foreign law. The seat of arbitration is in India. The foreign lawyers are entitled to practice in India as in today.
There is no restriction in a direct way, except that they can't do it on a more regular basis. It should be on a. I mean, if you see that the point there, they can.
No, as in today, can the
yes, they can.
Arbitration proceedings before an arbitrator.
Yes, providing legal expertise to a company outside India in any international arbitration case which is conducted in India, and such arbitration, foreign law may or may not be involved. So even if it's Indian law and foreign law are both involved, they can do it. There is no restriction.
This fly in and fly out does not apply, provided in the entire year.
You don't do more than
60 days. That's
okay.
What we say.
And
it's not very cheap, because the registration of a firm, foreign lawyer, is about 20, almost
$25,000. Yeah, the turnover is 6 billion. I don't think they'll worry about $25,000.
For a firm, it is 40 lakhs. Okay. For an individual, 20 lakhs. For a foreign law firm, it is 50 lakhs. And renewal 7 lakhs. 7 lakhs. And renewal fee for a foreign law firm is again 10 lakhs. So it is not that cheap. It's anyway.
As I said,
amount,
when the turnover is in an order of, the turnover is in an order of magnitude of $1.5 billion. I don't think they'll worry about $25,000.
And there is a guarantee amount of $40,000. That is almost 24 lakhs. Your Intel 25 lakhs almost. Now you wanted to know about the consultation process. The Bar Council, Karnataka State Bar Council received a letter from the Bar Council of India to place the letter before the Bar Council of India meeting and to debate. All of us, we deliberated on this, and we intimated that on reciprocal, our suggestion is almost identical to the one which you find in the rules, that it's only a reciprocal basis to the extent we are allowed to practice in that country without any additional qualification. Without any additional qualification. The degree I have obtained, for example, in National School or even Vivipuram Law College, should be straight away accepted there, if you want to bring them here to practice with their degree. Now, this is now I'll open the question and answer session. Kindly unmute yourself and you can ask the questions. I can see some message. Can a US law firm that would set up an office in India under the new rules, advertise its service. That is completely ruled out because we are governed by the Advocates Act 1961 and also the Bar Council of India regulations which provide for
Leave this lady 1 minute
the
once.
advertisement.
Nice out of everything.
Only 1 second. Because if you can see the rules to start with,
Direct your wheel. Where are your shoes and your wheel?
I suddenly have it.
Where is your shoe and where is your wheel?
You are riding it now all the time. Suddenly it fell.
Ash Bhushan ತವನೆ ಒಂದು ನಿಮಿಷ. Okay. Advertise ಪ್ರಶ್ನೆ ಬಂದಾಗ when it comes to advertisement, foreign law firms or foreign lawyers cannot practice unless they register with the Bar Council of India. So once they register with the Bar Council of India, then the Bar Council of India regulations, if not the disciplinary proceedings under section 35 apply. Therefore, when it comes to advertisement and all, it's a simply clear no. So they cannot advertise because the Bar Council of India regulations are very clear on this. Now kindly unmute yourself and you can ask the questions. All others, mute yourself unless you have a question to answer. Only 1 second, let me only 1 second.
Where is your shoe?
Okay, Sneha, you can ask the question.
So my question is
that your baby? Sneha, is that your baby?
no, it's not.
Okay, no problem, no problem.
Where is your shoe?
Okay, my
That's
first
not an
question-
international issue, that's a domestic issue.
Back then I'll again.
Yeah.
So my first question is regarding reciprocal basis. Now, which are these countries where Indians can go and actually practice? One that I know of is England and Wales. So how many such countries actually permit Indian lawyers to practice without
That
any
is here only.
So I think the, sorry.
Where your shoe? The park is here.
Hey,
Sorry.
one nimsha.
Where is your shoe?
Only 1 second. I'll try to find out who that imposter is. Maybe a foreign lawyer. Okay, Sneha, unmute yourself and ask the questions again.
no,
Yeah.
so my question
Sorry, your question was on reciprocity. The answer is in section 47 of the Advocates Act. This is something that by notification the government has to prescribe, and I think it's a bit convoluted in how it's worded. I'm just going to read out section 47, where any country specified by the central government in this behalf by notification prevents citizens of India from practicing the profession of law or subjects them to unfair discrimination in that country, no subject of that country shall be entitled to practice the profession of law in India. Subject to the provisions of subsection 1, Bar Council may prescribe conditions, if any, subject to foreign qualifications in law obtained by persons other than citizens in India may be recognized for the purpose of admission as an advocate. So, I mean, I don't know how this is meant to work, because it says that if, as an Indian lawyer, I face discrimination in a particular country, then persons of that country will not be allowed to practice in India. So it seems like it's a negative list as against a positive list. That's the sense I make out of reading section 47, and I defer to Mr. Basavaraj on this.
I do not know the countries which have allowed the advocates to practice based on the degree they obtain in India and also the enrollment with the bar councils of the state. I have to now find out, because now the avenues are open. I have to find out which are the countries that allow.
You better book your tickets quickly. There's going to be a rush.
No,
my
Yeah.
second question is, so a lot of tier 1 law firms mostly already have tie-ups with a lot of international law firms. They're also doing work for their foreign clients. Now, how will this really change what is currently existing? Like, how will this new rules bring in any change in that system that is existing?
I don't think so. I mean, to my mind, nothing there changes, because if you look at it, and that's the example I made about Bar and Bench and Daksha Legal and so on, reporting these transactions, you will find that there is already a lot of collaboration that's occurring. You will find that even in, say, an international commercial arbitration matter, you will have, say, UK lawyers or Singaporean lawyers or working along with Indian lawyers on a matter. It could, and very often, and you must be cognizant of this, Indian lawyers go to Singapore, UK, Paris, etc., and conduct arbitration there for typically Indian clients. So why should the converse not be true? So I think, really from that point of view, is anything changing for an Indian lawyer in a direct and dramatic fashion? To my mind, the answer is no. It's possible that if there are a large number of the foreign firms that come in and set up a presence here, will the local Indian work be taken away? Again, no, because the rules currently don't allow it. So, really speaking, on the ground for an Indian lawyer, there isn't too much that changes. Possibly, there is a lot of positive that will come out of it. Like I said, the systems that they can bring in, the expertise that they are able to show and things like that. But outside of that, I'm not too sure that there is a direct demerit that an Indian lawyer needs to be worried about. Perhaps the smaller firms, the mid-tier firms, you will see a lot more of them collaborating and being able to come together with, say, a foreign firm to be able to get a larger footprint of their operation. That might happen. And often what happens with let's say, one of the larger, say, US or UK firms, they set up offices all around the world. Because of the local restrictions, it could be in Cambodia or Indonesia or wherever, and typically even in India, they might say such and such law firm UK hyphen the Indian firm's name, LLP or whatever else it is. So there may also be a lot of more official tie-ups that come out, but I'm not too sure that it's going to dramatically and immediately change what is happening on the ground in India. You will see some evolution over time for sure, but are Indian lawyers going to get wiped out tomorrow in the next 6 months? I am not too sure that's going to happen.
So my last question, sir,
Sorry.
regarding
Yeah, go ahead.
soliciting.
No,
Now,
no.
what happens is if a foreign law firm or a foreign lawyer sets up their practice here, they obviously will already have branches in other countries. So other countries possibly permit you to solicit. So they're going to add an India tag to their already existing brand, right?
Correct.
So the soliciting is anyway going to happen. Has the Bar Council of India taken some, have they thought through this, or is there any possibility that soliciting rule as such in India may itself change?
Okay, now I was about to say something on these lines. For someone who practiced, enrolled 33 years ago, now what we saw during those days with the greatest lawyers like Datar and Yul Narendra was 100% ethical standards and the professionalism. Now, there was an inflow of Mumbai advocates and also Delhi advocates. With that, no doubt, the professional approach, there was a paradigm shift in the professional approach, the paradigm shift in the way we look at the profession and all. But unfortunately, the commercialization crept in. Because I have seen the change from 1988 to 2023. I can see the sea change in the atmosphere. There is a lot of commercialization in the profession, maybe because of the outsiders or maybe because of the changed standards and all. I'm only worried that this should not happen like a second COVID wave. The foreign law firms indulged in soliciting or commercializing or even advertising. But thanks to the rules, it also takes into consideration some of the aspects as a professional misconduct. And if they cross the limit, for example, if it amounts to, I'm not using the word unfair trade practice, but where the disciplinary issues and penalties are also provided in Rule 10. A foreign lawyer or lawyer associated with foreign law firm and registered to these normally be subject to same ethical and practice standards laid down under the Advocates Act and rules made thereunder, as are advocates enrolled under the Act. Whereas, so Bar Council of India can cancel the registration against which was granted under these rules if the soliciting is to an extent of crossing the disciplinary standards or ethical standards which could have been enforced against an Indian advocate under section 35. Therefore, this area can be interpreted according to me. I only hope that this will not result in a second round of commercialization of the Indian advocacy.
No, I think that way we're protected. But my question was more in the sense that they may not directly solicit in India. But today in the digital world, if you solicit, let's say if you put up a post on LinkedIn to say that, I'm providing these services in England, and while,
I understand.
see their
I
website and
fully
they
understand.
already have an
They
Indian.
will not do it in India. They will not do it. I understand the question completely. So far as India is concerned, there is a total ban under the Bar Council of India regulations. The question of advertisement is completely ruled out. Your question is, for example, and my understanding is, what if they do it in US? Large scale, advertisement, large scale exposure of their Indian counterpart, and what are they doing in India and all that. If that crosses the Lakshman Rekha, I think the Bar Council of India step in and cancel the registration in India. If they indulge in large scale advertisement of their company or their law firm in India, in abroad, for example, US or UK, Bar Council of India can certainly say, no, your activities of advertising in your country or in another foreign country is number one, detrimental to the interest of the local advocates. And number two, it amounts to a misconduct from the perspective of section 35 of the Advocates Act. It can cancel the registration. Certainly.
Okay.
Therefore,
Alright,
the question of they using the counterpart in India will be completely ruled out.
Thank you, sir.
Mr. Sagar Mudol.
Sir, namaste, sir.
Mr. Nandakumar, you are there?
Yes, I'm here.
Mr. Sagar Mudal has a question. You can start the video, Mr. Nandakumar.
Sir, I am unable to unmute my video right now.
No,
So
you are
can I ask
unmuted. It's okay. You can ask the questions, no problem.
Am I audible, sir?
Yes.
Please go ahead, sir.
Good evening, sir. Really, it was a very insightful session, sir. Sir, I have two questions. So, first one is, if foreign law firm hires Indian advocate who is enrolled with Bar Council of Indian State, so if he appears before any tribunal or court in India, is it permissible according to new notification? And already we have highlighted about this. So if any in-house counsel or associate of a foreign law firm who is Indian, if he appears before any court or tribunal, it is not acceptable, as you said. So, do you not think it is in contradiction with Advocates Act or Bar Council rule? Because until and unless a role of advocate ceases to be exist, he can practice before any court or tribunal. So, it is his legal right.
Can I take the question?
Yes, sir, please.
From the Bar Council perspective, I'll answer the question. If you're associated with a company, for example, some seed company or a pesticide company, you have to suspend your license. You cannot practice. If you're an in-house lawyer, forget about the foreign company. If you're in-house legal advisor to a company, ordinary seed company or pesticide company or aerated drinks company, you cannot practice. You have to suspend your license. You cannot appear before the court of law. This restriction is already there. And if you're a public prosecutor, for example, during that period, you have to suspend the license. You cannot appear as an advocate for any private matter. Forget about that. As a law officer of a company, you cannot practice before any court, tribunal, or authority. That restriction is already there. You have to suspend your license. And if you do not suspend your license during the period during which you are a law officer, that is a professional misconduct under section 35 of the Advocates Act. So that restriction is already there. Srimat Urvashi, yeah. Miss Urvashi, you can unmute yourself and ask the question.
Hi, sorry about that. I had a question. I wanted to clarify, you had mentioned that if a foreign law firm decides to merge with another law firm, like for example, there would be, the foreign law firm hyphen the Indian law firm LLP or LLC. in that case, can the Indian law firm then not practice anything in Indian law and they would only be able to give advice on that foreign law firm's jurisdiction? Or can they still go ahead and give India facing advice in that scenario?
I think
So
why-
quickly, I think the answer is that, well, if you are, if there is a partnership or whatever the rules prescribe, then it seems like that restriction will kick in. But what I suspect will happen is a loose association, where, and this is again a practice that's that is seen in, say, Singapore and Hong Kong, where what they will do is to say that it's like a slightly more formal, informal setup, if I may use that phrase, which is to say that all work that's coming in that's India law related, they'll pass on to the Indian firm, and any outbound work, the Indian firm will pass on to the correspondent firm. They will hold themselves out as best friends or whatever else. And I don't think that is a problem because that's not a restriction. What is a restriction is that if it's a foreign firm setting up in India and that foreign firm is registered in India, an Indian lawyer joins them, appears as a foreign lawyer, then there's a restriction on practice of Indian law. So yeah, I don't see that there will be a direct tie-up or a merger in a very direct way, because what typically happens is that they operate under the same office space or whatever, but they keep it under two separate banners and with Chinese walls. So the books of accounts are maintained separately, and they're able to show that they're two separate entities, but they pool in a lot of their resources for a bunch of other activities.
Just
Uh,
one more question.
just to continue, for example, recently there was a takeover of one law firm by another law firm in Karnataka. I think Mr. Nandakumar knows about it. Therefore, if there is a merger, suppose tomorrow the actual merger is permitted and the entire lock, stock and barrel, this law firm merges with the foreign law firm, then Roman 5 takes care of it. They all become the associates of the foreign law firm, and the restriction under Rule 8, Sub-Rule 2, Subclass Roman 5 applies. They cannot practice before the court of law, and they cannot practice Indian law if there is a total merger of one law firm with another law firm, where all the advocates become the associate of the foreign company.
I have one more question, I think, on that same front then. So if you know anything about the Denton's merger that they did with, I think it was Link Legal, because that predated this notification from the Bar Council of India. And from what I see online, it looks like it was a full merger. So in that scenario, can the Indian part of that merger, which would be Link Legal, then is that not allowed to do any practice in India anymore because of its tie-up with Denton's?
Yes, according to me, Rule 8, Roman 5 applies. And these words, that an advocate enrolled with any state bar council in India and is a partner, associate in any foreign law firm registered in India under these rules and regulations, can take up only the non-litigious matters and can advise on issues relating to countries other than Indian law. Such lawyers shall have no advantage, the right of an advice. So therefore, if there is a merger of the Indian company law firm with the foreign law firm, and all these lawyers become the associates of the foreign law firm, then the restriction applies. This restriction is triggered, and they cannot.
Understood. Thank you so much for your answers. So this was a very great presentation. Thank you.
Any other question? You can raise your hand, or Mr. Prasanna. Mr. M.R. Prasanna, you can ask the question. Kindly unmute yourself and you can ask the question. Mr. M.R. Prasanna.
Can you hear me?
Yes, yes.
I've been a General Counsel for.
Oh, Mr. Prasanna sir, how are you?
Very well, thank you.
Mysore Prasanna. Yes, sir.
We
I've
can't
been
see you,
attending-
sir.
Oh,
I will kindly start. He is a regularly he conducts seminars in under the banner of Mysore Prasanna. Kindly start the video. Kindly start the video. Yes, yes, yes.
I know I've been a general counsel for a very, very long time, and I've done international arbitrations and international mergers, acquisitions, and also various securities issues, which will require international counsel for the issuer, international counsel for the merchant banker, international counsel for so many things. So at the end of the day, there is also a question of if you're going to sell the securities in some overseas market, you need all their opinions, etc. So my point is that this particular regulation, it remains to be seen as to how it is going to facilitate the availability of foreign lawyers in India for advice on foreign law, whether it is English, US, or Canadian, to Indian clients at very affordable rates because they would have set up offices in India. But my point is that the rules currently framed are just a beginning, and they are not exactly very encouraging for people to jump onto the bandwagon, and there'll be a long queue of people wanting to register with the Bar Council. I believe that this should be taken as just a sneak preview of what are the things to come. And over a period of time, it would, like I really like Ratan Kumar's point about public consultation. How many international law firms were actually invited by Bar Council to actually make present and actually give their preferences to how they can still be in compliance with the Bar Council rules and the Indian law system and be able to actually open up offices? I don't think any such consultation really.
Delegates were there.
And I believe that that is something which should have been done. In any case, I can tell you, foreign lawyers will fly in and fly out in arbitration, also fly in and fly out on corporate transactions. They'll sit across the table representing a foreign party or even advising an Indian party who is doing a cross-border transaction. So I think the play is on, but if you want to really formalize, you need to have a very robust consultation process. Thank you for the opportunity to present my views.
Thank you, Sarabhan. I think I completely agree with what you said, because this to me is just the first step, and we need to see how this evolves. And like you rightly said, a more robust process of consultation and mutually agreeable accommodation might be a far better way going forward.
Regarding the foreign consultation, there is a reference to UK delegates, and the rules, the preamble says the UK delegates have also assured the Bar Council of India that the authorities in UK are also keen and interested in the means of collaboration, cooperation, and joint practice between Indian advocates and UK lawyers. There is a reference to the foreign delegates, and it is to be noted that the Bar Council of India is keen to progress on the idea of MOU between the Bar Council of India, the Government of India through Ministry of so-and-so, one part, and the Law Society of England and Wales, Government of UK, Bar Council of England and Wales, and the others. There is some consultation process only to a limited extent, not the overall. Of course, the state Bar Councils were consulted as a matter of fact, and we opined that it should be only on the reciprocal basis.
Yeah, Mr. Basaraj, you can imagine if an Indian law firm is asked to pay 25,000 pounds.
That reciprocity I'm not talking.
Mr. Prasanna, Mr. Basavaraj wants a higher fee to be paid to him when the foreign firms engage him.
Okay. What I'll do is 1 minute so that we can continue. On behalf of the Karnataka State Bar Council and KSBC Law Academy, I thank each one of the participants And a special thanks to Mr. C.K. Nandakumar, Senior Advocate, who has graciously agreed to participate in the discussion, has rendered a wonderful, insight into the entire scenario. So with the next seminar on equally interesting topic, we will meet again. Till then, good night and Shubha Sanjay.
Thank you. Thank you. Thank you, Mr. Basaraj, for the opportunity. Thank you.